Section 465 would also be applicable to challenges to interlocutory orders such as a cognizance order or summons order on the ground of irregularity of procedure. This interpretation is supported by subsection within bracket 2 to section 465, which states that while determining if the irregularity has occasioned a failure of justice, the court shall have regard to whether the objection could or should have been raised at an earlier stage in the proceeding. Therefore, the very fact that the statute provides that the court is to consider if the objection could have been raised earlier, without any specific mention of the stage of the trial, indicates that the provision covers challenges raised at any stage. The court, according to subsection within bracket 2, is to determine if the objection was raised at the earliest. In such cases, the investigating officer collects the necessary evidence during the investigation, and the evidence and materials so collected are sifted at the level of the investigating officer, and thereafter charge sheet is filed. The court has thus the advantage of the police report along with the materials placed before it by the police. Under section 190 within bracket 1b, where the magistrate takes cognizance of an offence upon a police report and is satisfied that there is sufficient ground for proceeding, the magistrate directs issuance of process. True it is that the trial court has apparently injected the respondent number 9 from altering the condition of the structure standing on the suit property, and the petitioner is now making a grievance that he has breached the injunction. Needless to state that since the petitioner has already initiated contempt proceedings for the alleged breach, those proceedings would take care of the grievance being put forth. The issue in the matter in hand is as to if a court commission is to be appointed to bring on record the present structure available at the site. As has been correctly noticed by the learned judge while passing the impugned order, condition of the suit property is not material for deciding the suit. The purport for which the request is being made for local inspection is nothing but an attempt to collect evidence to suit the purpose in the contempt proceedings. The position that emerges from the above discussion can be summarized thus: the power of the High Court in quashing a criminal proceeding or FIR or complaint in exercise of its inherent jurisdiction is distinct and different from the power given to a criminal court for compounding the offences under Section 320 of the Code. Inherent power is of wide plenitude with no statutory limitation, but it has to be exercised in accord with the guidelines engrafted in such power to secure the ends of justice or to prevent abuse of the process of any court. In what cases power to quash the criminal proceeding or complaint or FIR may be exercised where the offender and the victim have settled their dispute would depend on the facts and circumstances of each case, and not category can be prescribed. However, before exercise of such power, The High Court must have due regard to the nature and gravity of the crime. Heinous and serious offences of mental depravity or offences like murder, rape, dacoity, etc. cannot be fittingly quashed even though the victim or victim's family and the offender have settled the dispute. Such offences are not private in nature and have a serious impact on society.